Good morning. I'm Wally Dietz, the Director of Law for Metropolitan Government of Nashville and Davidson County. With me is Associate Metropolitan Attorney Allison Bussell. Allison heads up our very strong litigation group in Metro Legal. And we're both here to speak about the injunction that was issued yesterday and to answer your questions. We appreciate your being here. We know it's a very busy time. So thank you for coming. Our system of government is based on checks and balances. When one branch of government violates the Constitution or overreaches, our independent judiciary is designed to step in and protect constitutional rights and the public interest. That is exactly what that three-judge panel did yesterday. In passing the Metro Council Reduction Act, the legislature was guilty of egregious overreach. The governor sided with the legislature. We had no choice but to go to court and protect Metro's rights and the public interest in having an orderly election. We are very grateful that the court heard the case and ruled expeditiously. The court's decision yesterday should be a sign to the legislature that it cannot do whatever it wants, regardless of the Constitution, regardless of the public interest and the impact on the public as a whole. We're hopeful that they will pay attention to this ruling. I'd now ask Allison to step up.
Good morning. I'm just going to give a brief overview of what the court ruled yesterday. So the Metro Council Reduction Act that we challenged in this lawsuit does two things. In Section 1A of the Act, the legislature set a cap on the size of metropolitan councils at 20 voting members. In Section 1B of the Act, the legislature imposed impracticable requirements on Metro Nashville specifically to draw new districts, cutting its council size at least in half. And those requirements were to do so immediately in advance of the May 18th qualifying deadline. Yesterday, a three-judge panel enjoined the second of those provisions. The court agreed with Metro that the provision imposing these immediate redistricting requirements illegally targeted Metro Nashville in violation of the local legislation clause in the Home Rule Amendment in the Tennessee Constitution. The court also agreed with Metro Nashville that the speed with which the act required this redistricting is impracticable and undermines the public interest. Now that those requirements have been enjoined, we look forward to all of Metro's claims being addressed in the ordinary course of the litigation. The three-judge panel has set a status conference for Monday, and we are ready to proceed.
We're happy to take any questions.
Wally, what do you see as the course of business if indeed the state decides to take this up to the Supreme Court immediately?
Okay, I'll let Allison speak to that process.
So if they want to ask the Supreme Court to review it, we think there are myriad reasons why the Supreme Court could potentially deny that review. The trial court ruling here was very narrow and very restrained. They enjoined only the parts of the act that impose these immediate, urgent requirements. And we believe that the Supreme Court very well may decide that now that the urgency is gone, that this litigation through its ordinary course can address the merits of all of the claims. We also believe that the Supreme Court is likely to see that just a year ago, the state essentially made the opposite argument in the Moore versus Lee litigation when it said you can't take steps that interfere with an election this close to the election itself. In fact, that case was proceeding along a very similar election cycle as our case, and that Moore versus Lee ruling covered numerous pages of the trial court's opinion. So the trial court certainly agreed that interfering with an election at this late stage would be detrimental to the public interest. So we believe the Supreme Court very well may decline to accept the case on those grounds.
What happens if the Tennessee Supreme Court agrees with the new law?
So several things have to happen before they could do that. One is the state must appeal. And the state publicly said last night they were reviewing the decision and deciding whether or not to appeal. There are very good reasons for the Attorney General not to appeal this decision for all the reasons that Ms. Bussell just stated. Then, if they do decide to appeal, they have to have permission. And the Supreme Court does not have to accept the appeal. The Supreme Court has discretion to say, we're not going to take the appeal at this time. And we think that is the most likely result because, as we all know, the qualifying deadline is May 18th. Today is April 11th. It is too late to implement this act in this election. This three-judge panel ruled unanimously that it was too late and that the integrity of the election itself was in jeopardy. So we don't think the Supreme Court will see a need to jump in and accept the case. That leaves the remainder of these claims to proceed in the ordinary course. We have constitutional claims that were not litigated in the injunction hearing last week and weren't before the court. So the rest of the case can proceed, and we'll see where they go. But if the Supreme Court does not vacate this injunction, we will go forward with the election as originally scheduled, 40 council members with the districts that were drawn in January of 22, 15 months ago.
Just to clarify, you plan to continue on the process based on the pre-planned August council election?
We are suspending our plans to enforce the law for this election. While it was the law, we advised the council and the planning commission that until there was an injunction, it was important that we comply with the law as passed and as signed by the governor. So the Planning Commission did that. The Metro Council met several times to discuss how to implement the law, but now the law is not in effect. So there is no reason for the council or the Planning Commission to move forward with implementing those drastic changes on that drastic timetable.
So that means that the redistricting process will stop during the injunction?
Yes, the redistricting process will stop. The Planning Commission is working on a statement to go on its website that will say that. There is currently nothing in front of the Metropolitan Council by way of resolution to go forward, and they will not. They will not go forward because the law has been enjoined. It cannot be implemented at this time.
Aside from the upcoming election, can you speak generically about why it's important to have a 40-person council?
Why it's important to have a 40-person council? Because it's what the voters of Metro Nashville want. The brief history lesson here is in the first referendum to approve the Metro Council, the proposed council size was 21. A lot of voters, in particular African-American voters, were concerned that their rights would not be protected with that few number of council members. So the next charter proposal went to 40, and then in 1962 it passed with significant support in the African-American community. And so for 60 years, since April 1st, 1963, we have had a 40-member council. In 2015, the voters rejected a referendum to reduce the council to 27. It's important to have a 40-member council because it's what the voters of Metropolitan Nashville want. It should be the decision of the voters of Metropolitan Nashville to change that number if they so choose, and they can by referendum. Yes.
To expand on that, in just given the context of this weekend, this fight over representation with the legislature, can you situate this lawsuit within that broader context of voting and representation in this red state, in this blue city?
Yes. Let me say that up until we filed this lawsuit, my sense is that people all over Nashville were feeling hopeless and powerless, that there was nothing they could do. They were concerned that the legislature had carte blanche to do whatever it wanted to do, and that it could punish Nashville as much as it wanted to, and there was nothing we could do about it. So the mere fact that we filed this lawsuit, we received expressions of support and gratitude from people all over Metro. And then winning the injunction yesterday affirms that the legislature does not have carte blanche. We believe that this should redefine the relationship between the legislature and the metropolitan government. So in the broader scheme of things, looking at the relationship, it's really important that the state of Tennessee and metropolitan Nashville have a good, healthy relationship. We actually believe this ruling can help improve that relationship and rebalance the powers. Steve.
Given that there's still constitutional claims to litigate, if the Supreme Court were to vacate the injunction, is there time to litigate those constitutional claims in time to implement this in this cycle?
Good question. Ms. Bussell.
We would say no to that, and that's precisely one of the reasons we would suggest that the Supreme Court may not take the case, because there just really isn't anything that can be done with this act as it is currently written to implement it for this election cycle. We took the position we couldn't do it as it was written without the injunction. It certainly can't be implemented now on what would even be a more delayed timeline. So we would submit that even if the court were to reverse the injunction or lift the injunction, so to speak, any remedy that would flow from that could not affect this election cycle.
So again, the ruling was considered illegal because of the time constraint, or because that they ended up constitutional because voters weren't able to decide it?
So that's a great question. In the injunction analysis, the court looks at 4 different factors. Those are the likelihood of success on the merits of the claims, and then the potential harm of an injunction to the state, which would be the party opposing the injunction, the harm to Metro if an injunction were not granted, and then the public interest. What interest does the public have either way? And in analyzing each of those factors, the court found unanimously that the public interest weighed in favor of an injunction here because of those timing requirements that you are mentioning, because you can't shift the rules that close to an election. People need more certainty. People need to know what district they're voting in. People need to know if their voter registration card is reading correctly. So for that reason, on that public interest factor, they found that an injunction was necessary. On the likelihood of success argument, however, the timing was not the problem necessarily. The problem was the Section 1B of the Act, which imposed these requirements only on Metro Nashville, violated the Home Rule Amendment, because you can't have legislation that is local in form or effect imposed on one locality without voter approval or local legislative body approval. So the answer is kind of both. They agreed with us from a legal perspective that our claim was likely to be successful, and then they also found that the timing provisions created myriad problems, and that the state really had no interest at all in imposing those unreasonable timing requirements.
So aside from the possibility of the Supreme Court taking this back up, I mean, is this over? I know you had mentioned something last time about 2027.
So it's not over. If the Supreme Court, if the state appeals and the Supreme Court does not take the appeal, then whether or not we have to implement the 20-member council this year, that question is over. The answer is no, we do not. we go forward with the election on August 3rd, as we had been planning for ever since January when the new 22, when the new maps were approved well over a year ago. So as in terms of what kind of election we have in 2023, the answer will be final and resolved. We go forward as planned. There are other issues about whether the statute is constitutional that could change what Metro needs to do in 2027. But there's plenty of time for those constitutional claims to be litigated in the ordinary course.
So Republicans stated that this wasn't targeting Nashville specifically, but Nashville was the only locality that was being affected, right?
The court agreed with our argument that this bill targeted Metro Nashville. We put on proof from the legislative record that Nashville was the only local governing body that was affected. The court agreed with that argument, so we won that point, and that's what led to the finding that Section 1B, which changed the rules for this election in the middle of the election, that section was unconstitutional. Some people have said the Home Rule Amendment is not applicable anymore, that we would never win a case on the Home Rule Amendment again. Well, we proved them wrong. We had a 3-0 decision from judges across Tennessee saying the Home Rule Amendment is very alive. And to the extent the legislature targets Metro and only Metro, that legislation is suspect. Any other questions?
Other bills that the legislature's passed this session that have been seen as state overreach in the city?
Yes, there is a possibility. What is clear is that in January, legislators launched an assault on Nashville with bills that affect the council, the authorities, our ability to do several things, where it appeared that Metro was the only target of that legislation. We have now succeeded in blocking, at least this year, the implementation of one of those bills. To the extent legislation targets Nashville and Nashville alone, we are taking a very hard look at that. We don't know if those bills will pass, if they will be signed by the governor, and what the final form will be. But we are watching them as they progress through the legislature, and if we determine that the bill affects only Nashville or attacks our charter, which is our Constitution, we're very likely to take action. All right. We appreciate your time. Thank you very much.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.